If something happened to you tomorrow, who would raise your kids? Who would manage their money? Most parents don't want to think about it, but if you don't make those decisions, the court will, and it might not be the person you would choose. Hi, I'm Jennifer Nichols with J. Nichols Law. I help families across Texas protect what matters most: their children, their legacy, and their peace of mind. If you're a young parent without an estate plan, stick with me for just a few minutes. This could change everything for your family. Estate planning isn't just for the wealthy or the elderly. It's for anyone who has someone they love and something they care about. For young families, the most important reason to plan is your children. Estate planning gives you the ability to decide who would take care of them if something were to happen to you. Even more, without the right estate plan, your children could inherit money or property directly. But minors can't legally own assets. This means a court would have to appoint a guardian of the estate to manage those assets, which can be a lengthy and expensive process. The right plan protects your kids and manages your assets wisely. It also keeps your family from getting stuck in a costly legal mess. One of the first steps in estate planning for young families is naming guardians. In Texas, you can do this in your will or a separate legal document called a declaration of guardianship for children. There are two types of guardians: a guardian of the person who handles day-to-day care, medical issues, and school stuff, and a guardian of the estate who handles money and property, including inherited assets. But here's the thing: appointing a guardian of the estate can get expensive and complicated. That's why we recommend setting up a trust for minors. Children under 18 can't legally inherit directly, so we create a testamentary trust in the will. This allows a trustee to manage a child's money on their behalf. You can even choose the age at which they receive it. This could be 18, 21, or later. I typically recommend 25. The trustee can be a close friend or family member, someone you trust to be responsible with money. The trustee can pay for things like school, healthcare, and daily needs. This can be either directly or working with the child's guardian. If you have a young family and you have retirement accounts, those need special attention. We often create a retirement benefits trust for the benefit of children to receive those funds, since minors can't inherit directly. For married parents, we recommend naming the spouse as the primary beneficiary and the trustee of the retirement benefits trust as the contingent beneficiary. For divorced parents, we recommend naming the trustee of the retirement benefits trust as the primary beneficiary. Naming a retirement benefits trust as beneficiary instead of your estate can minimize taxes and keep things simpler and more secure for your children. Life insurance is also crucial for young parents. If something unexpected happens, life insurance can help pay for day-to-day expenses, easing the burden on your loved ones. For married parents, it's best to name your spouse as the primary beneficiary. To ensure your children are cared for, if something happens to both parents, name your estate or a trust for the benefit of your kids as the contingent beneficiary. Never name minor children directly, as they legally cannot receive the funds, causing delays and complications. For divorced parents, name your estate or a trust for the benefit of your kids as the primary beneficiary. This ensures the funds are managed responsibly for your children's benefit. Estate planning is not just about planning for emergency. It's also about helping your kids thrive in the future. We recommend families set up savings tools such as UTMA accounts and 529 college savings plans, so you can start building for what's next. So let's recap. You can name guardians for your children now before the court has to. You can protect their inheritance through a trust and decide when and how they receive it. You can plan for your future, for your assets, and for your peace of mind. This isn't about fear. It's about love, responsibility, and protecting your family on your terms. If you're ready to take that first step, I'd love to help. Schedule a consultation with me at J. Nichols Law. Let's build a plan that gives you clarity and gives your family protections that last. Don't forget to like, share, and subscribe for more tips on protecting your family legacy. Thank you for watching.